Okay, so today we're going to be resuming our discussions on contracts. We're going to go with chapter 15. Let's see here. Today is March 22nd. So it's today chapter 15, 16, 17, and 18. And it's going to be that continuation of just a little bit more detail of contracts in writing, some of the parole evidence rule, third party contracts, performance breach and discharge, and then contract remedies if there is a breach. So we're going to basically be continuing what we discussed last week, and this is now just more details of contracts. Before I do get into that, I just want to reiterate in case there are students who are not going to be watching this now live and they're going to be watching a later time, make sure to check the syllabus for when your exam actually is. And if you have any questions on material, you can always email me and I will respond back when I have a chance. If there's a particular topic that you need some help with, make sure to read the textbook first and then watch the video. And then if you still don't understand the concept, then certainly reach out. So when we talk about contracts, we've spoken before and we said, all right, contracts can be in writing and then they can also be oral. Oral contracts are still enforceable, but there are some contracts that must be in writing in order for them to be enforceable. And Chapter 15 talks about which contracts of that nature must be in writing. So we can generally say that oral contracts are enforceable. I don't really like oral contracts. I've kind of given you my reasons why. I think that when you rely on an oral contract, an oral deal, you're kind of setting yourselves up for problems because just people tend to forget things. You don't know, you're not going to go into as much detail when you're talking about contractual, the nitty gritty. You're not going to be able to discuss all of that, verbally, and then also memorize it. So when you put things down on paper, you think about it a little bit more, and then sometimes more questions pop up. And it's okay if questions come up, and then for the parties to negotiate and see what works and what doesn't work. And as long as you have an understanding of what you're contracting over, then it's okay. It's really not a big deal, that you're going back and forth and you're discussing things in more detail and coming up, well, if this scenario happens, this is what I'd like to be done. If this happens, this is how I want it to end out. That's part of that negotiation aspect. So the textbook gives you a couple of different things that have to be done in writing in order for them to be enforceable. There's some that I'm going to concentrate on that I want you to know. I will give you the 5 that are listed in your textbook, and I'm going to tell you which ones I really want you to know. So this one is a listening. It's promises to answer for the duty of another, and that's when you have a third party coming in, um, who's stepping into the shoes of one of the contracting parties. So let's say you have a contract between A and B, and you have C coming in now, and they're gonna step into A shoes or B shoes. When you have that third party coming in, and now they're gonna be taking over that responsibility for somebody else, then that has to be in writing. The second one, also a listening. This is when you have an executor or an administrator. So when what we talked about wills, and when somebody passes away, and if I do sharing now is responsible, that must be in writing. So when you have a will that the person before they die, they name somebody who they want to be in charge of their estate. And when it goes to court, the court decides who's going to be the fiduciary, whether it's a will or if there's no will and it's an administration. So when you have somebody who's now stepping in and becoming an executor or administrator, that must be in writing in order for it to be valid. So when people say, oh, well, so and so named me, they wanted me to be in charge when they died, unless that's in writing, it doesn't really matter. It has to be in writing and it has to be certified by the court. The third one, this one I want you to know, it's pretty common sense, but I'm going to say it anyway. This is when you have marriage. And marriage, don't forget, is a contract between two people. So a, word of mouth or hey, a handshake, we're married, that's not good enough. That you're going to have to actually get a marriage certificate in order for that to be a valid agreement. So definitely know that marriage must be in writing in order for it to be valid. One of my other classes, somebody brought up common law marriage. I don't know what that entails. I don't know how much proof you have to have. I don't believe common law marriage is recognized in the state of New York. I believe it is in Pennsylvania and a bunch of other states, but I don't know enough about it, so I'm not gonna surmise. So for the purposes of this class, regular marriage, not common law, regular marriage has to be in writing. This one you must know, this next one, and we've spoken about this before, and it has to do with transferring interest in land. So when you are buying property or selling property, when you're buying or selling property, that must be in writing. You're buying a house, you're buying a condo, you're buying anything like that. Yeah, it's great to have a handshake with the owner or the realtor or whoever it is. Yes, I'm going to buy it. Yes, I'm putting an offer down. Yes, it's all wonderful. But unless you have that contract that says you're buying and selling that piece of property and those items we talked about are actually listed, it's not good. An oral contract for the sale of real property is simply not sufficient. It would not be recognized in a court of law. So whenever you're buying and transferring real property, that must be done in writing. That is the most important one. I definitely, definitely want you to know that one. The last one, now we go back to listening. It's agreements that are not going to be performed in a year. If something is going to take longer than a year to perform, a service contract, the building contract, or any type of contract where whatever it is that you're agreeing to is going to take longer than 1 year, that must also be done in writing. Don't forget that this is general information also. When you have different states, in the country, you have different parameters perhaps, or there's maybe different things that the states would say or designate that they want in writing. So particular statutes, particular laws, case law might say that whatever, this particular type of agreement must also be in writing in order for it to be enforceable. So this is just general information, which can change when you look at state to state. Let me see here. Okay, the estate of Jackson versus Devon. Let me just see if that was actually in your syllabus.
It is in the syllabus.
That one is in the syllabus. Okay, who read it and would like to tell us about estate of Jackson versus Devons?
I can talk about it.
Okay, go ahead, Damar.
So, but I think they're not gonna find it in the book. It's page 280 because I think the new edition is just they have it at the end of the chapter. So Jackson and his neighbor Denovan's, they agreed that they're gonna buy from Jackson like 120, sorry, 79 acres of his land for the amount of $120,000. They had an agreement, they put it in writing, and then he said that he would like to keep 1.3 acre for himself. Well, the agreement had a drawing and dimensions, and then they agreed about that in February. He died in May. His whoever inherited him, they didn't honor the agreement, so the diviners sued, and then the court said that because the agreement didn't have a specific description of the land, let's say a lot number, block number, whatever, it didn't have specifically, so it did not comply with the statute of fraud, so they couldn't honor the agreement for them.
Okay, great. Anybody here ever bought a house and looked at the actual contract or the actual deed?
It usually describe everything in the about the property, where it start, where it ends, what does it
Exactly.
include,
Yeah.
and lot number, block number,
Yeah,
everything.
it's very, very specific. It's I see some people here like writing stuff. Let's see. In the process, help my parents with the process. Yeah. So you actually, like, when it's now time to transfer that deed, I mean, you have like latitude, longitude points. And generally speaking, houses are not, it's not like a perfect square or anything like that. So you might have a lot of these point designations that tell you where a piece of land ends. And the reason this is so important and so many problems occur when there's transferring of land, it's because, you may have neighbors where, they've been in the neighborhood for so long, and one neighbor, put their fence or whatnot on what they thought was their land. When you have a new purchaser now come in and they get the survey done and they see that, no, wait, your fence is actually on my property, then sometimes these problems happen with neighbors because on the actual transferring of land, you'll see who owns what. And so, that adjoining neighbor maybe have been used to the past 5, 10 years having their, a fence on this piece of property, and then they find out they have to remove it. Obviously that's going to cause problems, a lot of problems, and that's why there's a lot of sometimes civil litigation between neighbors, and it may over be like 6 inches or a foot or 2 feet of land, but especially in New York, that land is precious. So that 6 inches or a foot can give you a little bit more. And so you always want to be careful when you're purchasing or selling land that the lines are exact. Don't ever get into an agreement with your neighbor and say, yeah, you can do this, it's fine, I have no problem, or can I do this, because it's going to cause problems. Your property is this. If they're going to allow you to use it, whether you're buying that piece of property and you have that in writing, that 6 inches, that foot or whatever, put that in writing. That way it carries with the land itself and it becomes part of that contractual obligation. Very good, Amar. Very good. Okay. This is now listening. We also talk about, in this chapter, the sale of goods. And we mentioned before that the sale of goods, the law kind of looks at, section 2, article 2 of the UCC, and that is really kind of what governs, kind of, I guess, contractual obligations or whatnot between the two parties. So it's just when people are looking for guidance, section 2, article 2 of the UCC talks about, the sale of goods. This is just listening. What also talks about this chapter, and what I'm about to say should ring a bell, is the theory of promissory estoppel. And we heard the theory of promissory estoppel when we talked about the case of Skeba versus Cash, right? So we can talk as much as we want about how contracts should be in writing, but don't forget that the theory of promissory estoppel says an oral contract will be enforced if one party justifiably relied on a promise, and the court can only avoid injustice by enforcing it. So whenever you hear the term promissory estoppel, I want you to think of that case, Skeba versus Cash. That was the case where the guy had entered into this agreement with the owner of the company. He was going to leave, and the guy's like, no, 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 stay. I'm going to give you, $250,000 if you stay. He stayed. He was a good salesperson. And then when the company was sold, he waited for his $250,000. And he's like, we don't have a contract. We had nothing. But the court still upheld that because the court saw that this person relied on that oral promise. He stayed with this company because he relied on that oral promise. And so not to enforce it would be, to have injustice happen. And ultimately, the court wants to see justice, the right thing, actually happen. So that's the theory of promissory estoppel. The next legal theory that I want you to know. So I want you to know promissory estoppel. This is something I want you to know. I also want you to know the parole evidence rule. And the parole evidence rule is also another legal theory. And it kind of talks about, well, you know how when you're doing, I'm going to explain it, and then we can write down the definition, or whichever way you think you're going to understand it best. So whenever you're actually entering into a contract with somebody, there's a lot of back and forth, right? Legitimately, it's I'll give you this for that, no, I don't want this, and you go back and forth a lot. The parole evidence rule says all that offer, negotiation, all that stuff is great, but the contract is only what's in the four corners of the document. The agreement that's going to be bound is what's in this document. So when you actually look at a contract, if you've ever signed on one, it'll say towards the end, usually, that this agreement encompasses the entire understanding of the parties. You can't say, oh, well, yeah, he told me or she told me to sign this, but we had a side deal going on. My understanding was based on X, Y, and Z. No, that's not how it works. Whatever it is that you decide must be put in writing. Do not leave things up to chance. Do not say, well, I understood what he wanted. We agreed to it. They're a good person. You know what? Doesn't matter. Doesn't matter. I have my sister and my parents entered into a business deal with one another. I made them get a contract where both sides were able to negotiate certain terms, and that contract has been referred to on multiple occasions when both sides have different recollections of what the understanding was. It's important, especially when you're dealing with family, especially when you're dealing with friends. It doesn't matter what side deals you have going on, always put it in writing, because a good lawyer is going to say, look at the four corners of the document. They agreed on everything. Everything was written down. This is what the document stands for. This is what it is. So that is the parole evidence rule. That's everything I want you to know for chapter 15. Does anybody have any questions on any of this stuff?
Time.
Huh?
We get the time.
I do.
Successful.
Tyrese, do you have any questions?
No, I'm sorry.
That's okay. Okay.
Yeah, I do.
Go
On the
ahead, Amar.
syllabus, there was a marriage provision, like you had it listed there. I tried to read it. I didn't understand it. I
Which
don't know.
one, Amar? Say it again. Which provision?
Marriage provision.
Yeah, the marriage provision, I just want you to know generally that marriage must be put in writing. So you get a license from the state. There's actually a contract where both people sign it and there's witnesses to it. And that's all you need to know. Does anybody else have any questions? Okay, we're going to move on to chapter 16. And chapter 16 is third party contracts. So generally, like, the way to simplify things is when you look at a contract between two parties, but sometimes you assign a third party an aspect, a duty of this contractual obligations. And sometimes a third party can have rights in a contract, and the way that that's done is by three different ways. It could be done through an assignment, it could be done by a delegation of duties, or it could be done where there's express terms in a contract that call for a third party. This is now writing it down.
Sorry,
Go
what
ahead.
was the last one?
The terms, express terms in a contract, call for a third party to be included. So again, a third party has rights in a contract. How? It could be by an assignment, it could be just a delegation of duties, and it could just be that the terms of the contract say there's a third party that's involved. This is something I want you to write down. The only requirement in an assignment is the intention. So for an assignment, the only requirement you need to have is the intent to assign it to somebody else. Okay, now stop writing. And then this can be done orally. It could be done in writing. It could also be done orally. So if you have a contract between two parties and one party was supposed to have an obligation. So simple, I am hired by a homeowner to build a house. I'm a general contractor. What I'm going to do is I'm going to assign or delegate some duties to third parties. How? The most common scenario is I'm going to have subcontractors. The contract is still between me and the homeowner. But am I personally going to go ahead and like make the tiles on the floor or in the bathroom? No, as a general contractor, I'm going to go get a person who's an expert in plumbing. I'm going to get somebody who's an expert in kitchens. I'm going to get an expert on the floors. So the contract is between me and the homeowner, but I'm assigning this duty of building the kitchen, although that's what I'm supposed to be doing. That's what I'm getting paid for. I'm assigning that duty to somebody else, a third party, or I'm delegating the duty to the guy who's going to paint, right? Or the contract between us could very well say, you know what? I'm going to be hiring third-party contractors, subcontractors, you only have to pay me, homeowner, and I will pay everybody else. So the price you're giving me, it's up to me to find people who are going to work for you. You don't have to worry about any of that stuff. I'm just going to do it. So again, that's kind of, I think, the best way to explain, third-party contracts. Um, Also, you don't necessarily need, new consideration. So it's not like because the contractor's hiring the subcontractor, not every time I need to hire a new subcontractor, I have to go back to the homeowner and get a new contract. Absolutely not. The deal is between me and the homeowner, and I'm going to just do whatever I need to get done in order to fulfill the end of the contract. So there are, however, some rights that you can't assign to somebody else. So like the example I gave you with the contractor and the subcontractors, I could hire whoever I want to. The deal is between me and the homeowner. But there are some things that the law says they are highly personable, and you cannot hire or delegate or assign those duties to somebody else. And I'm going to give you some examples. So I would love a family portrait. So I seek out this famous painter who I love her work, and I hire her to draw a masterpiece of my family and I. So I go to her, we book a session. It's like 6 months in advance. I go there, and she greets me, and then she's like, "Oh, my understudy's gonna do your painting." Is that gonna work? I see Amar shaking her head. Right?
No,
No,
because you hired her because of her talent.
exactly.
So if you
I
want
hired
someone else,
her. That's right. I hired her because of her talent, her expertise. I want her to draw the picture. If I wanted her understudy, I could have hired an understudy. If I wanted somebody that's just about to learn, I could have hired that person, right? So that one, highly personable. I don't want that person to do it. What about this is also clear cut, so there should be like no question. So, two people contract with one another to enter into a marriage, right? You can't assign that duty to somebody else. So if A and B are supposed to be marrying one another, one party can't say, you know what, I'm not feeling this contract. I'm going to assign my duty to marry you to somebody else and have a third party step in. That's also personal. You can't do that, unfortunately. So that agreement would not work. The other one, I'm going to give you a couple of more examples. Physicians, right? That's going to be tough depending on the kind of physician you're going to. If I have a brain tumor and or some kind of cancer or something very specialized, where it's only like 1 in a million that have it, and I seek out a particular physician to do this, I travel from New York to California because that's where this expert of a doctor is, and I go there. I finally get there, and he's like, "Oh, he called out sick that day. He wants his partner or like a resident to do my surgery." Is that a task he can assign to somebody else? No, I want this particular person, right? I want this particular doctor with this set of skills. How about, and again, this is really for the people who are going to be having children or had children, OBGYNs or internal medicine. You can go to one, if you go to a practice with multiple OBGYNs, and if you're pregnant, you're going to see a whole bunch of doctors because you don't know who's going to be on call the day that you deliver. So you can get this one, you can get that one. Yeah, you might have a favorite one, but it doesn't matter. Either one can deliver your baby. It might not be something that's highly specialized. Maybe there's more skill or whatnot, but again, it's not. There's they deliver babies. You go to internal medicine so they can check to see if you have a cough or whatever it is that you have. A bunch of them can do the same thing. It's not that specialized where there's only 10 doctors in the country or the world that specialize in that particular thing. The last example I'm going to give you is also with an expert, and that's an attorney. If you go to an attorney, you watch the commercials, you've seen them, the billboards, Celino and Barnes, Johnny Cochran, any of those, because you want them to represent you on a case. that you hired this particular big law firm and you know that the matter is on for an adjournment or just a status conference. Your attorney hires an assistant, also an attorney, but it's an associate. Can they do that? Yes, they can. Yes, they can. And the reason I said specifically it's an adjournment or a status conference, it's not a big deal. That can be assigned to somebody else. You don't need a particular attorney with that special set of skill to say, hey, judge, we've completed discovery. We're going to move on to the next phase. Or, judge, we haven't met discovery. We need to adjourn this for another date. Not highly personal, So even though you hired Celino and Barnes or Johnny Cochran or whoever this high, big profile, you know, attorney, they don't need to be involved in every single step of the way. Maybe you need them for the trial, maybe you need them for the negotiation, for the actual settlement, but not for every single step of the way. Okay, so things that are very personal, you cannot assign. Okay. In Ray Magnus, let me see, was that also on the syllabus?
Yes, it was.
It was. Okay, great. Who wants to tell me about that one?
I can do it.
Great, tell me.
Okay, so there was this couple, Magnus and Redmond. They filed for bankruptcy, and they were golfing members of this club. So their trustee wished to assign their golfing rights to other members, either like on the waiting list of this club or like other people. But the bankruptcy court found out that the club's rules to be anti-assignment, so therefore the state could not assign rights contained in the golf agreement.
Excellent. Very good. Excellent. So, if you're familiar with like these country clubs and, golf clubs or whatnot, you could have a membership to them, but you cannot assign most of them. You cannot assign that membership to somebody else. Why? Because in order for you to be a member of this particular club, you have to go through a whole application process. They have to, screen you out. They have to see if all the members have any problems with you, if they like you, what your reputation is in the community, all this, hoopla.
Yeah, so
So
it was a personal contract, not an assignment. No, it couldn't be assigned.
it could not be assigned. Exactly. It could not be assigned. It's highly personal to that individual person. It cannot be assigned. Very good. Excellent.
Actually,
Um,
the club made the terms of the contract very like as a complex relation, so they cannot consider a commercial contract as
yeah.
well to prohibit any assignment.
That's right. Yeah. It's based on that particular person. It's not something where, it goes for everyone. It's not like a Six Flags. In even Six Flags, you can't even assign your membership. It tells you when you buy it, you cannot give it to somebody else. When you go to Six Flags, they take your picture. It's only for that particular person. So it's not even just fancy clubs. It's I'm sure Sesame Place, Six Flags, all those places are like that. It's particular to that individual. Let me just see if there's anything else I want you to know for chapter 16. Okay, that was pretty much it. Okay. Does anybody have any questions so far? All right.
I do, but about the previous chapter as well.
Okay.
Sorry, it's time computing.
That's for the 1 year calculation of when a contract starts. So remember, I was saying that if a contract is going to take more than 1 year, it must be in writing. So if you enter into a contract with somebody to build a building, you're going to erect a building for them. You're a contractor also, and it's going to take you more than 1 year to complete the job. That has to be in writing. But if you're going to be able to, you're going to tell, I'll be able to get this done in a month or 2 months, you don't necessarily need to put that in writing. It's not selling, transferring a piece of property, right? It's contracting to build something. So it's not that it has to be in writing because it's real property. It's just that construction aspect. So that's the computing. If it's going to take less than a year, doesn't need to be in writing. Think back to also remember leases when somebody was renting. If it was less than a year, didn't have to be in writing. If it's more than a year, it has to be in writing. So that's the idea behind it. Anybody else have any questions on chapter 15 and 16 before I move on to 17? Okay. Okay, so the last thing I have actually in chapter 16 is just delegation of duties. So don't forget that there are certain duties that are not assignable. You cannot delegate like and this is common sense, but I'm going to say it anyway. You cannot delegate illegal activities. Okay. So you are not happy that you have a competitor. You can't tell your assistant to go kill your competitor because that's illegal. You can't kill people in general. You can't hurt people in general. You cannot run people over in general. So just because you delegate it and as part of your, business strategy to, disarm the competition, it's still not right. You can't do that. So you cannot delegate anything illegal. Okay, so that's it for chapter 16. We're going to move on to 17, which is performance, breach, and discharge. So sometimes people enter into a contract, and that contract, it could be contingent upon either a happening or a non-happening of an event. And so it could be, the example I have in my notes is, let's say two people are entering into a contract to buy a used car. And you see it on the, like everybody puts things on the internet nowadays. So through cars.com or so through this, Craigslist or eBay or, I don't know, there's a whole bunch of ways to sell cars now. And so you see that it says, on the picture that this particular car has 40,000 miles. You speak to them, that maybe they're in a different state or whatnot, and you say, listen, I'm going to come, everything looks good, I did the Carfax, I'm going to buy this car as long as it has less than 40,000 miles on it. Now, yeah, it's got the less than 40,000. You go there and it actually has 45,000. Are you obligated to buy it? No, you put in, even if you had already entered into the contract and you have some kind of, document between you, you entered into this contract with a contingency in place that says, I'm only going to buy this vehicle if it has less than 40,000 miles. You put an express condition. So you may be wondering, what's an express condition? Now, because that's part of your, the stuff that's in the textbook. An express condition is a condition that is clearly expressed. It is written in there. You're not going to guess or, be wishy-washy. It specifically says, if this happens, then Y. If this doesn't happen, then X. So you have something express in there. You can have express conditions about a lot of different things. You can have contingents. Again, let's go to real estate for a minute. You enter to buy a house. If you've ever bought a house, and I know somebody says they're in the process right now, right? A lot of times, so you enter into an offer, you write the offer, it's accepted by the seller, but you have contingencies in place. Some of the most common contingencies are subject to a mortgage approval and an inspection, a home inspection, right? So if you have those two things in there, and even though you have an offer, you have a contract that both sides have signed, if you don't get a mortgage approval, you're free and clear. You're not going to be obligated to go through with the purchase. Or if the inspection comes back and there are substantial structural problems, you don't have to buy that because you said, I'm only going to buy this house if the inspection comes back okay, So you're having contingencies in place. If those contingencies are not met, you are not obligated to continue with that contract. The other thing in this chapter that I want you to know, this is something that I want you to write down, and I do want you to know, is a concept called a satisfaction of a contracting party. Satisfaction of a contracting party. And this is really, depending on which side you're on, it could either be really good for you or really bad for you. So if you're an artist, website designer, some kind of designing thing, right? You make clothes for a living, and you have a customer, or you tell your customer satisfaction guaranteed. If you're not satisfied with the product, you don't have to pay for it. Well, you're putting in there this express thing of satisfaction. It's a clause, satisfaction of a contracting party. So if make this website based on the specifications of your client, and they say, you know what, I don't like it. And what don't you like about it? I don't like X, Y, and Z. And you fix it up and they still don't like it. And you fix it up again and they still don't like it. How many times are you going to fix it up in order for them to like it? Well, your contract says satisfaction of a contracting party. You told them that the customer has to be, satisfied, guarantee satisfaction, or else they don't have to pay. So when you put something like that in writing, it's really, you're kind of screwing yourself if you're the artist, because satisfaction is really subjective, right? It's up to the person, their taste, whether or not they're going to be happy or they're not going to be happy. They're going to like it or they're not going to like it. So are you really going to, how many versions of this website are you going to do? How many painting revisions are you going to do? How many articles of clothing, like if you're a tailor, revisions are you going to make so that this person can be satisfied? So you should always, if you are that creative person, you should always have some kind of clause or something, satisfaction guaranteed within reason. Okay. Or, after 3 drafts, then, a charge is going to be made every time you do another draft or something like that, because it could go unlimited. Look, people don't intentionally try to screw one another when they're entering into a contract together, because ultimately, what's the goal of a contractual relationship? It's both sides are trying to get something. I'm trying to get that dress, or I'm trying to get that website. So I want to work with you. But there are some people that are pains. So you also want to cover yourself in that respect. So that's satisfaction of a contracting party. So we talked about express conditions, we talked about satisfaction of a contracting party, implied in conditions, implied in fact conditions. So basically that's a condition that's not express, it's implied. So if I hire somebody to paint my house, okay, you're going to start painting on Monday. Great. It's Monday morning. It's implied. I'm going to tell you the color, I'm going to provide you the paint. Like, you're coming to paint, but you're not going to paint the color that you want, right? So it's implied. I'm going to give you a little bit more information on that so you can do your job. The next legal theory is, or definition, is discharge. And there's 2 different types of discharge. There's discharge by performance and then discharge by breach. Discharge basically says, it means, the termination of a contractual duty. So discharge is the termination of a contractual duty. So if you're discharging by performance, it means both sides did what they had to do. And so now the duties for both sides are finished. Everybody did what they had to do. Everybody can go home. Discharge by breach is one side or both sides didn't do what they were supposed to do. And so this is a breach of contract now, because one side or both sides did not do what they need to do. And so the next, logical step is going to be that breach of contract, and then, lawsuits or whatnot. So that's discharge. It's just the completion of the obligation of one side, whether it's by performance or by breach. Next, when we talk about breach, is material breach. I want you to know what that term is. Material breach, it's like a major breach, a substantial breach. It's, you hired somebody to do to make you this cotton dress, and she, uses wool instead, right? Very different materials. You hire somebody to paint your walls cream or eggshell, they painted a hot pink, completely not what you wanted. That's not even like, oh wait, I can live with this. No. So a material breach is a substantial obligation that has now not been fulfilled, something major. It's a major thing. uh, a minor breach or something that's not major would be like, instead of cotton, she used a 90% cotton, 10% nylon, material. Or instead of painting the egg, she painted the eggshell. So it's, hardly noticeable, to the naked eye, but you just know. So it's a very minor versus a very major breach. So that's material breach. Frustration of purpose is when sometimes things happen where it's nobody's fault, and so you cannot carry out the actual agreement because something happened, and so both sides or one side cannot perform their duty. The best example is what's happened in the world over the past year. People had weddings planned, people had parties planned, people had, vacations planned, right? Coronavirus hit. You cannot have that wedding, you cannot fly out. So you might have had this agreement between you and the hall. It's no fault of either side, but that plan now cannot take place. So sometimes the purpose or the agreement is no longer feasible because of something that happens in the future that you were not anticipating was going to happen. And so you can either negotiate a new contract or depends on both sides. If they're amenable to modifying the terms, then that could be done. The last thing for this chapter is bankruptcy. What is bankruptcy? Bankruptcy is you have a lot of obligations financially and you're not able to pay them. So you declare something called bankruptcy. All your creditors are given notice that you cannot pay. You have like a bankruptcy trustee, and they basically will sell all your assets or as much of it as possible, and you pay as much of the money that you can to a portion, a pro rata share to these creditors. The problem when you do that is obviously it kills your credit. So you're not going to be able to buy anything of value for a very long time. So that's bankruptcy. I do want to give you the secret phrase before I forget. It's in phrases, and I am going to use the same one I did. Okay. I don't believe I gave you this one already, so, or maybe I did. Today's the 20th. Hold on. 22, no, actually, not going to give you a new one. Okay, today is March 22nd, 2022, and my kids are extremely noisy and annoying. The phrase is, my kids are extremely noisy and annoying. It's true. No, it's not. So that's the phrase for tonight. My kids are extremely noisy and annoying, and then we're going to move on to chapter 18, moving right along. So chapter 18, yeah, that's it, because it's true. They know that, and they just don't want to acknowledge it. So, stop it. So the next day, the final chapter, right? I think, is it for today? Let's see here. What do we have? Yeah, chapter 18 is the final one for tonight. It's now you've entered into the contract and something's going to happen. There's some kind of breach, right? So what are the remedies for breach? This is something I want you to write down. This is definitely something I test on. What's the most common remedy when there's a breach of
Monetary
contract?
compensation.
That's it. Monetary compensation. What makes it all okay if there's a breach of contract? It's monetary compensation. You get money and you're fine and everything is okay again. Because again, the court's looking at a number of different things. Have you been made whole? Had this contract actually gone through? Where would you stand? It's not supposed to bring you in a windfall, but at least it's supposed to put you in the same position you would have been had there not been a breach of contract. So again, the most common remedy when there is a breach of contract is monetary damages. There are also a couple of different other ones I'm going to talk about. It's the two other ones I want you to know are specific performance and injunction. Specific performance is sometimes money is simply not good enough. You want the other party to do what you had contracted over. All the money in the world is not going to make up for it. You want them to do what it is that they want, that you were supposed to do. And one of the examples, this is a real life example. There was this house that this was years ago, that like I was looking for houses. My husband and I were looking, and there was this house that my colleague from work saw. It was like down his block. And he said it was an elderly couple. They had renovated the house. It's gorgeous. It's in a nice area. It's got a swimming pool. It's got an elevator in the house. And, they're selling it for the parents died. And so the kids, they don't live here. They just want to sell it. So I started looking into it, and then I saw that, there was, like it was in the courts, and I wasn't sure if it was foreclosure or whatnot. I find the attorney on the case, and I called him up and I was like, what's going on with this house? And he's like, well, this house actually had already, like, the kids of the owner had already entered into a contract with buyers. They didn't realize that they actually priced it too low. So they entered into this contract, and now they were trying to get out of this contract, trying to get more money for it. But the other side, they're not backing down. Like, they want specific performance. They're saying that this house is like no other. It's not a cookie cutter. It was built by a contractor. Like, it had all these wonderful features in it. They were not backing down. So in a case like that, he was like, stay away from this. This is going to drag on for a long time. And in it, money, you getting your deposit back from that contract is not going to make you all better. You can get, 50,000 in penalties or what. You're not going to be able to get that house, because it's so unique. It's features that you want, that specific performance. You want that particular home that you had contracted over. So that's specific performance. Injunction is quite the opposite. Injunction is when you want somebody to stop doing something. So an injunction is, somebody is building a swimming pool. Your neighbor is building a swimming pool. And so they have a contract with this swimming pool company, but they're digging, and it actually caused a problem in your land. You file an injunction. It's to get them to stop whatever action that they're doing because it's somehow affecting you. So an injunction is getting somebody to stop an action. Specific performance is wanting them to continue to perform the action, and monetary damages are just getting money so you can go away. So those are really the most common remedies. The most common one out of three is the monetary damages. That's most of them. It's monetary damages. When we talk about, like, now monetary damages, and we talk about costs and how they're calculated, I'm going to give you an example. This is going to be something I'm going to use the little whiteboard here for, because I want you to, there's a lot of different ways to calculate things, but this is really just a simple way to calculate, an example. So let's say I hire a building. I always use this example because I think it's the easiest thing to kind of show people, a way to calculate damages. So I hire a contractor and I tell the contractor, I want you to build me a hotel that has 1, 2, 3, 4, 5, 6, 7, 8, 10 rooms. Okay. And every time I give them an essence, time of the essence clause, which means I need this done by a certain date and time. And I know that if I rent out each room, I can get $100. So each room is $100 per night. So when I'm at my full capacity, how much am I going to actually be able to get if I have this thing totally rented out?
Per month?
For the month, yeah. It's gonna be actually
1,000.
not, you know what, let's do for the, let's say I can get $100 a month, or $100. If we do $100 a night times 10, how much is that? That's 1,000. Thank you. My
Yeah,
7-year-old with the
1,000.
numbers. That's sad. Okay, so it's $1,000 per night for a month. That's how much for 30 days? So I'm gonna get,
$30,000.
oh, you're right, 30. That's why I'm a lawyer, not a mathematician. 30,000. Okay. So that's 1, 2, 3, 4. 1, 2, 3, 4. Okay. So that's $30,000 a month. In order for me to have this thing operational every month, my overhead expenses are, 5,000. I need this by actually December, so I can rent it out for New Year's. The contractor delivers it January, 1 month late. I'm going to sue him. What's the maximum I can recover here?
25,000.
That's correct. How did you get the 25,000?
Because if he's not gonna rent all of them, he's not gonna have expenses. That means just 25,000 he's losing.
Yeah. he can't sue for $30,000 because he would have made the $30,000, but with the $30,000 comes overhead expenses. So he can't sue and recover more than the maximum he would have made anyway. So 25,000 is the maximum recovery here. Does that make sense? I'm not hearing no, so we're gonna go with a yeah.
Yes.
Okay, so stop sharing. Let me look at this thingy here. Yes. Okay, so that's a way to calculate. It's always up to the side suing to kind of show the court how they're coming up with their numbers. So if you're suing based on a breach of contract, you spell out, well, you know what, I lost out on this because of that. I lost out because of, this on that. And so you kind of list it out. And so you use the theory of promissory estoppel. You use the theory of justifiable reliance. You use the theory that I just showed you with this. You bring all your numbers, your exhibits, your spreadsheets, and you show the court what you could have made, but you didn't. And then it's up to the court to decide, what you will be granted or what you will not be granted. Let me see here. Cost avoided. Punitive damages. What are punitive damages?
Excessive amount of damages to give a lesson for other
Yeah.
wrongdoers.
Yeah. What's the
Should
word I
be
always
like
want you to know? That when it comes to punitive, there's one word I want you to equate it with.
punishment.
Punishment. So punishment, right? When you have punitive damages, it's a punishment. So when you hear punitive damages, I want you to think of that tobacco case that we had. The tobacco case, that was a good way to do it. Let me just see here. I'm just gonna look at your syllabus because I don't. Okay, so Hadley versus Baxendale and Parker are on here. Christopher, go to another room. Okay, who wants to tell us about Hadley versus Baxendale, if that was in your book?
I can.
Anna, you did one. Amar, you did one already. So anybody else?
I can do it, Professor.
Excellent. You just saved your class. Go ahead. Tell us.
All right. So basically, the plaintiff had a mill, and something broke. From what I remember, I think it was a crankshaft or something.
Mm-hmm.
And they went to the defendant to fix it, but they never told the defendant that they will be missing revenue, and they wanted it in a specific time, and the defendant was late. So when they received the crankshaft, they asked like, oh, we had all of this time that we didn't get money, so they sued them for the time they didn't get money.
And what did the court say? You remember? So far you're on point. You're exactly right.
Yeah, I don't remember exactly, but I think they sided with the defendant.
They what?
They sided with the defendant.
Do you remember why?
Because it wasn't a reasonable ask. I don't remember why exactly.
No, you're right. The court
I know
basically.
why.
Go ahead, Amar.
Because they didn't communicate to the carrier clearly the urgency of when they need it, because they stopped working. So, but they didn't tell that clearly to the defendant. So the defendant makes sure to get it on time.
I'm going to correct both of you because you both used the word defendant, and don't forget defendant, and we only use that when it's a criminal case, and this was a civil case. So the respondent here, they never communicated to the person who was fixing this thing, hey, you need to get this done, we need this right away, because they figured they have another crankshaft. They didn't think that, this entire mill was going to shut down, which is essentially what happened. So it was not foreseeable that their entire operation was going to come crashing down, or that they weren't going to have an operation at all. That was never communicated to them. So the plaintiff who was suing was not able to recover for those damages because it was not foreseeable. Very good, Bessian. Very good.
But I did read
Yes.
that the company that was supposed to repair the shaft said that it was going to be ready in a day. So why wouldn't the plaintiffs get some compensation from it? Like,
very good question. Very good question. it was late. It was the carrier who was bringing it that was late. So it wasn't really any fault of their own. It was like the way that it was being transported. Had they known perhaps the urgency of it, I believe in the case it said that they thought they had another one that was operating. So even if it was a couple of days late or whatnot, they didn't think it was going to be a major problem. Today, nowadays, if somebody needs something within a certain period of time, there's always a clause called the time of the essence. Like if I need something by a particular date, you have to specify that I need this by a certain date. If I don't have this item by this particular date, I don't want it anymore. Then we're going to have a breach of contract. So in this is an old case also. I think it's from the 1800s. So things have certainly changed a little bit, but the idea behind it, which is foreseeability, and that's really what I want you to get out of this case, the communication aspect and whether or not it's foreseeable that an entire company or corporation is going to shut down because they don't have this particular piece. Any other questions? That was a good question.
But by the way, the book keeps saying defendant. And I was telling myself why they keep saying it as well.
Yeah, they keep
Yeah.
saying defendant.
Yeah, I mean, that's a lawyer in me, it's like, it's not, they're not on trial here. But anyway, that's just me. Okay, the last case for the night is Parker versus 20th Century Fox. So that's the last case. Who wants to close out the evening by telling us Parker versus 20th Century Fox?
I can give.
Excellent. We have different people today. I love it. Go ahead.
I told them I have exam. I can't read everything myself.
All right, that's good. Teamwork.
Yeah, we prepared very.
I like it. Good.
So this actor was employed to do this movie with Fox. She signed a contract. I'm pretty sure there was like a minimum amount of like $750,000, and then Fox wanted to do another movie, or I'm pretty sure that's what happened. They hit her up to like do this other movie and said, you're going to do this one instead of the one that we already contracted with you. And then she sued for breach of contract and wanted like money from the first contract that they had. That's all I remember.
Okay. Do you remember what the court said or what the conclusion was? You're right. So far, you're right.
The court side with her, the actor.
Yeah, they sided with her actually. And so there's some cases that I don't necessarily agree with the outcome, and this is one of them, but I'm not going to tell you my personal opinion. We're going to kind of analyze it with the way that the book has it, and then I'll tell you my opinion. So the book says that this was, and the court reasoned that the new contract that she had, or the new movie that they offered her, it took away some of her perks. It took away the fact that she had was the ability to decide who I think the director was. It was also a different genre of movie. The first movie she was singing and acting, dancing, and that's what she was kind of known for. The second movie was a Western, so it didn't really highlight her skills. And so it was inferior in nature. So that second movie that they changed it to was inferior to her talent and skill and whatnot. And so they said, all right, here's 750,000, even though you didn't do anything, because she might have lost. And I guess I'm trying to, think of it from their perspective. She lost out on other movie opportunities by signing up with them. So she did not get a chance to choose or have another opportunity. There was that loss for her. So the court did side with her. They gave her the 750, which is the amount she would have gotten had she performed that original movie. So again, I don't necessarily agree with that. I don't see that she mitigated. There was no mitigation of damages. She didn't try to make it better. There was no negotiation on her part to try to say, okay, well, let me have some kind of singing, acting part. Let me have, choose this or that. She just kind of flat out said no, and she sued, and well, it ended up working in her favor, so she ended up winning.
But also, on the contract, it said that there was the guaranteed compensation for playing like the first movie. So wouldn't that be enough reason for the court to side with her, for example?
She was going to get compensated, but I would have felt better if she had been asked or did that second movie. So they gave her the 750 without having any mitigation of damages. There was no other negotiation or contractual obligation to perform another movie instead. Yes, she has to be paid. Absolutely, fine. But what did she do? Because it's as if now she kind of, in my eyes, she got a windfall. She got the 750. She didn't have to perform this. What was the time that it would have taken her to perform and finish that particular movie? Was she now able to do a second movie in between and also make more money? So that's just really like the way I kind of analyze things, but I'm not going to hold you responsible, obviously, to what I think. It's really what the book says. She was entitled to this 750,000. A contract said, you know, she was going to get paid. She was going to pick the director. She was going to sing and dance. It was going to be filmed in Australia. This was a completely different movie. The court said it was inferior in nature, and so they sided with her and they gave her that money. So that's really what you kind of need to know. And I usually do test on this case, so make sure that you are familiar
I
with
just wanted to ask, so what we can say literally now, the concept of this case, because it has too many things.
It's I would say it's something inferior in nature. It's inferiority. So that's what I want you to know out of it. Yeah, it's a lot of money for back then. I don't think I didn't realize it was the 60s. I thought it was the 80s, but still, it's a lot of money. So let me see if there's anything else I want you guys to know. We already talked about specific performance, injunction, and that's pretty much it. Does anybody have any questions on any of the material that we covered this evening? So to recap, your next exam, which is in April, it's going to be after your break. It's going to be the same thing. It's going to be on Blackboard. It's going to start 6:30 on that Monday night. It's going to cover information from chapter 9 to 18. I have not finalized it, so it's going to be multiple choice, probably somewhere between 20 and 30 multiple choice, and between 5 and 10 true and false. Do not you know, don't think it's going to be easy because it's, you know, less chapters than your first exam, first third of the semester. I ask you specific question. It is open book, so you're still going to have from 6:30 until either 9 or 9:15 to finish it. Once it's submitted, it's submitted. And that's pretty much it. This is not a group project, so make sure you do it individually. So you do your exam, you finish it, you submit it, and you'll get your your results right then and there. Does anybody have any questions? Okay. If you have any questions, you can always email me. Have a wonderful break. I will see you April. Well, I'm not really going to see you because the next exam is going to be the April 5th is going to be the exam, but I'll see you. Actually, hold on, because I might have another announcement to make. April 5th. April 12th, I'll see you. I'll see you April 12th. All right. Good night, everyone.
Good night, Professor. Thank you.
Have a good night.
Good night. Bye-bye.